Yeah, we need a shop. Better to work out. You got doors.
I guess you have a big one.
I hope so. When's the railroad coming up?
Some irregularities in the data.
Oh, right, so that's put off for a week or so?
For a month, yeah.
Okay, that's convenient.
Yeah, I was a little bit confused.
I think it's kind of a good point to make, but I gotta make myself anyway.
That's probably, because you involved them, right? Yeah. Oh, we didn't know that. Yeah, you definitely have.
And the other thing is, what accessory use buildings?
Yes, we do for you. Well, actually, this is, just to, Joe, clarify something, this is nothing to do with the buildings over there that got built on here. That's the museum. Okay, that's what I thought. So for them, actually, it's not. It's an accessory use. If the property is divided, I'm not sure how that works there, how they have that separated with the leases to the museum. Hey, Joe, can you clarify what the property that's there is the railroad lease, the museum will lease property to the railroad or the railroad property?
Each owns their own parcel.
Oh, they do.
The only thing that's leased is the right of way that the county owns with the track.
Okay.
But the railroad has slowly but surely been acquiring parcels over the years, whether mobile homes or one thing. So they slowly but surely bought up the contiguous parcels. So they own what they own out the regime owns what it owns.
So this is an accessory building, or this is not a residence, obviously?
No, it's strictly a locomotive
A
shop.
workshop. But there are any other structures on that part of the property that the railroad owns?
Yeah, there's a section house, there's an old house, kind of a converted mobile home, that the crew used to hang out in and store things.
And another which is small.
Right, so we'll look over that.
And the other thing is that the railroad museum is one entity, and then the new building is another ownership, I think it'd be accessory use.
No, but they're separate pieces.
It's a total separate,
Yeah. They're looking to
two separate corporations, two separate owners. One is for profit, one is not for profit. There's Empire State Railroad Museum, not for profit, sorry, there's a museum called Astronaut Railroad Incorporated, is nominally for profit.
Just turn your mic on.
Well, no one's ever made a dime off any of the above. We tried ourselves as for profit, the opportunity regarding the freight business.
Great business.
Yeah, intermodal, stuff like that.
Well, that's something that's coming back on.
This is a decision of Larry Lewinsky drew up. This is to do with the apartment.
We're ready whenever you're ready.
Start with the pledge of allegiance.
Lieutenant, Rolf Reese,
Here.
Joseph Michaels,
Here.
Keith Johnson, Gary Blumetti,
Here.
Mark Lodi.
Here.
sit down. Yeah, no.
Nothing I'm aware of, no. So you're gonna make a motion to open the hearing?
Yeah. Okay, let's open the public hearing. We may have to hold off on making the determination. I'll make a motion to open the public hearing.
I'll second.
You ready for us?
And we had a motion to open the public hearing in a second.
Yes, I got it.
Yeah, I seconded.
Yep.
Okay, the roll call.
You need a vote?
Yeah.
Board Member Johnson?
Yes.
Board Member Reese?
Yes.
Board Member Lodi?
Yes.
Board Member Michael?
Yes.
Board Member Guglielmetti?
Yes.
Great. Proceed.
All right.
Good evening, everybody. We've been here before, and I think you generally know why we're here. We've got an application for an area variance for a rooming boarding house guest cottages. It is a permitted use in this district. We were referred here by the planning board because they felt that the prior use and the new use are somewhat different, and as a result, the 100-foot setback needed to be addressed. You've got a map before you which shows the distance from the property lines. And again, you're probably very familiar by now with the standard for an area variance. There's a 5-part test in the New York statutes, and it really boils down to a balancing act between the benefit to the applicant and the detriment to the neighborhood. The applicants have made out their case that this is the, in their opinion, the best use of the property. I know there are people who feel as though this is not an appropriate use for the property, but in reality, if you look at it objectively, I think you'll see that before these were long-term rentals. With a long-term rental, what does that mean in terms of the impact on the neighborhood? With a long-term rental, the impact is that you've got people living there with their families, they're coming and going. I think in many cases there are 2 cars to a family in this day and age. We've got 3 units. If there were 2 cars to a family, there would be as many as 6 vehicles coming and going from the property. With the proposed use of short-term rentals, what we found is that there are an awful lot of folks who come in and they use the buses. So there is not the vehicular use of the long-term rental situation. There is an inn nearby, not in the same zoning district, but nearby. And again, these are 3 units. This is a permitted use, and I just don't really think that you can make out a strong argument for a significant detriment to the immediate area. The long-term use of the property shows what's been going on there. This is just short-term use, and I just think if you apply the statutory standard, understanding still that this is a permitted use in this area, this is not a use variance, this is an area variance. And I think you've also got to sort of protect yourself from concerns being raised about what else might happen. There was an unfortunate article in a newspaper which gave everybody the idea that this was going to be a 3-ring circus. It's not. This application is limited to this one particular use of the property. There is no intended use for any other purpose. And I think you're going to hear stories about Airbnbs. This is not an Airbnb. You're going to hear stories about what happened someplace else, perhaps. That's not what this is about. So if you just focus on what is actually in front of you, I think it's fair to say that this is not an inappropriate use, it's permitted use. The impact, the detrimental impact on the neighborhood is really quite insignificant. You know, it's a very natural thing for people not to want change. I think that's just the nature of things, and particularly in communities such as ours, people like the way it is. They don't like things to change. Of course, change is inevitable, and if you're going to have any kind of a change, the kind of change you want, I think, is the kind of change that's going to benefit the neighborhood. Here you've got a young couple, they're raising their family here, they're involved in community activities, and if they were denied this opportunity, it's hard to say whether or not they're going to be successful with this property. So we ask you to simply apply the standards that the statute provides, and not get sidetracked with issues that people would like to sort of cloud the issue and bring up other points. If you just look at what's going on here, and you look at the people that are involved, and you look at the long-term use of the property, the benefit here to the applicant is quite significant. It may very well be the difference between success and lack of success. And the detriment to the area is, for all purposes, really non-existent, despite the fact that other people might not like the idea that there's any change at all. If there's going to be any change, this is a rather insignificant change. And again, the nature of the use is such that, in fact, the traffic impact will probably be less with this use than it was with the prior use. That's all I have to say. Thanks for your attention.
If anybody else who's arrived late and would like to speak, please come and sign the assignment sheet.
What's that?
You said it.
I don't. Okay. I went about a few things.
State your name.
Oh, Ellen Morelli. I live at 25 School Lane.
Okay.
I behind Mr. Bailey's property. And Mr. Bailey made a visit to my house to remind me I should only speak tonight about the variance. Once you have a variance, you can come back and get another variance, as we have seen with Mr. Higley. And we certainly don't want to see that going down that road, because I say a person, when they have done something in the past, that tells me what they're going to do in the future. Now, Mr. Bailey said he was going to do all these things, have concerts, pop-up dinners, corporate events, weddings. He also said he never had anything there, because I brought up the subject of on one evening there were 30 cars parked on Home 14. But I did find out that yes, he did have, that was a concert that night. On June the 25th, he did have a concert there. And he also was told that he should not continue doing what he's doing, renting to transients, on September 30th by the planning board. He has not stopped renting. He has continued to rent. He rents every weekend. He's booked right through January. He has every intention of doing everything he said he was going to do. And we are a community of residents. We don't have a business. If he wanted to have a business, he should have bought in a commercial area. Now, he has transients coming. We have no idea who they are. They could be who knows who. He's very dangerous, too. He's got a young daughter.
I object.
You may
Personal
object.
accusations are really inappropriate.
That's okay. We don't want to have transients coming every weekend. Different people doing different things. With dogs that run on people's property, people that walk on people's property, cars coming and going. It's not appropriate in our area. If it was a small bread and breakfast where you have people coming on the weekend and they stay, they're doing other things, but he's looking to have a lot of things on his property. And we do not want to have concerts. We do not want to have weddings. He hasn't got a big enough piece of property to do all those things. And we have plenty of inns for people that want to do those things. So I don't think it's appropriate, because I think when you do give him a variance for this one thing, he will be back all the time, because he's going to do what he's going to do. Thank you.
I live
letter in here. Okay, Tracy Quick is next.
I'm Tracy Quick, my husband Jim. We live at 102 State Route 214. First of all, I'd like to say that my husband was raised in this area. I was raised in a small town of Prattsville. I know what community is. Right now, I'm not hearing stuff that makes us feel like a community. We're right next to Jeff and his wife, Brooke. They do have a small child. And yes, there have been cars that have been parked on 214. That was for the cobblestone, or better yet, for whatever the big yard sale was. I was opposed to that also. I have not seen that. The one occasion that there were cars there was that Jeff and Brooke had a party. It was not a concert. I know it was a party and not a concert because I've been to concerts. We do not oppose them having this setup with transients coming in. We've lived next to Pauline's house for over 20 years. There have been less desirable people living in those apartments at times than someone as a young couple with a child buying in this area. They're not from New York City, as it's been stated before. They're from Connecticut. They had businesses in the city. And as all young people, you are either going to make it or you're not, and you're going to think of what's best for your children. I lived in Queens for 4 years and found that being raised up here, it wasn't the best solution for my family. I've never had any problems with them. If I've had questions about anything, or if I saw somebody's dogs, I just said, there is a leash law. Everything's been fine since then. I don't think there should be some kind of lynching where you've got a couple that are trying to make it, if everybody can work together, to have a community. They're a young couple that bought a house, thrilled to buy a house in the country, a piece of property that has 3 apartments. They're excited. What can we do? What can we do to help the area? Jeff had told me his father was a fireman. He has relatives in his family that are firemen. So he became a member of the local fire department, Nisha. To me, that is bringing yourself into the community, making yourself part of this community. I just do not see, and we're right there. He's even said, if it bothers you, I'll even put a fence up. But I do not see where that is going to be a problem. Do I want big parties and cars in front of my house? Absolutely not, because we all know that 214 is not set up for cars to be parking there. We've had our mailbox hit 3 times from people coming around the corners. But I do not see where that's going to happen, and we support them having their little place that people come up on the weekends. As far as variances go, those variances, if they should come, can always be denied. Thank you.
Can I just answer to one thing? To the fact that they said there were no
We have your
concerts.
day in court.
Yeah, until we get through everybody first.
Can I submit this, that there was a concert on June the 25th?
No, can we just, let's get through the signing.
Okay.
It was a private party.
You guys, if you have any comments, Tracy, send them up this way,
Okay.
not to each other in the audience. Thank you.
Peter Savant.
Good evening, gentlemen. My name is Peter Stefanich. I reside at 116 Route 214 in Phoenicia, New York. Mr. Futterfast, in his application, stated that many of the rentals were bus drivers or bus users. He provided no proof of any of that. The other question I have is, as a rental units, tax-wise, it's supposed to be a boon to the community, but I wonder if record keeping is being maintained. As far as my opposition, it is not against Mr. Bailey or Ms. Baxter. Yes, I don't want the character of the neighborhood to change. Rental properties tend to be, when you rent to a tenant, better vetted than short-term tenants, as in weekends. The only other thing is that certain assurances were made at the last planning board hearing, and I have witnessed people walking, trespassing on Ms. Miller's property, and also unleashed dogs since that time. So that's just my opposition. It's not malicious. I believe this community has a right to want things to remain. Thank you. Oh, one other thing. Has the board read, do you want me back there? Has the board read the appellate decision regarding another rental unit? Similar situation?
No. Completely different situation.
It's a different, but,
Completely different
okay.
situation.
I just want to make that, yeah.
Karen Miller was on this. Do you want to have them read the letter?
You're up,
I
Karen.
didn't hear you.
She signed in to speak.
I signed here in case I wanted to say something, but right now you got my letter.
Did you want the letter read?
You got to read the letter?
Yes. I don't know if you want to let everyone speak first, or do you want to read the letter now?
If she doesn't want to speak, she doesn't have to.
So do you want to read it now, or do you want to go on to the next person?
Go to the next person.
Okay, Diana Hartel.
I live at 120 on 214, just 2 more houses down. I've had pleasant interactions with these folks. I'm not close enough where I would see the dogs or whatever else is going on, but I believe those are relatively minor issues that can be resolved. And that there should be rules, of course, in our neighborhood. The question would be, are the renters coming in appropriate to the neighborhood? So I don't know what mechanism exists for having some screening in place if you're renting. I don't know how that works, or could it work, but it would reassure everybody if there is some way of making sure that the people coming in are not going to be disruptive and not going to have wild parties and everything else. And I think these folks also would want that. I don't know them well enough to say that definitively, and I'm not going to speculate either. I think speculation's out of place here. I believe in the rules, the neighborhood rules, what the neighborhood wants, and the rules are long-standing. We apply the rules, it should work out.
Nobody else knows.
Can I answer for this?
We're going to read the letter.
Want to read the letters first? Go ahead.
This one's from Karen Miller. It says, I am here as a concerned citizen and the owner of the adjacent property to Bailey Baxter's. The individuals purchased this property to do the short-term rental and have various other venues on this property. When they first thought about, or during the time prior to closing, they should have gone to the zoning enforcement officer to see what was needed to establish this business. That is what a responsible business person would have done. They're individuals that have had several businesses and should have known from prior experiences, as they have in many instances been skirting the law. That doesn't give me a lot of faith and trust as to what they will continue to do if they're given the permit. I, for one, was accepting the fact that, yes, I could live with it, not happy about it, but sympathetic to their needs. This is their livelihood, and I didn't want to put them out on the street. However, the other day, they both approached me in such a negative way, making it seem like it was my issue, and I created this scenario when it was a lack of poor judgment themselves. I now have to be more proactive in my thinking and determining if I do wish to have my property and the community jeopardized with these short-term rentals. Zoning laws are a part of living in a democracy. Just because one doesn't know what a current zoning code says doesn't make one right, it makes one ignorant. Why should a homeowner in a residential community, as the Bailey Baxters call it, retirement community, in which short-term rentals were never contemplated to be the norm, be forced to accept this change in the rules and be forced to live beside the hotel because an individual wants to modernize and change the environment in a residential area and the community by inviting in an endless number of strangers? How does that contribute to the existing community? Mini hotels shouldn't be allowed in a residential zone. It's very disconcerting to have strangers continually arriving and departing from your neighbor's home in a residential neighborhood who are clients, not friends of the homeowners. Where are our rights? It seems defenders of this practice only look at the hosts and don't seem to care about the rights of the plain, ordinary, middle-class citizens who worked hard to own and maintain their property and pay taxes here. These individuals, if they weren't caught, would not be paying any business taxes to this community. I also have the same issues with all the other short-term rentals in the town of Shandaken. I do not see the activities going on in the house. The guests are pretty much staying off my property, but I still have a few which there should be a sign in each unit stating where their property is. I do see individuals still backing out onto 214 when they're blocked in, as there is no structured parking in the driveway. My concerns are the way they have dealt with their endeavors in the past. Once they get their permit, they will inch their way to get what they want. They're not going to be individuals that will be happy just having weekend clients. They're too young and absorbed in making things happen. That's not bad, but not in a residential area. That was one. Want me to keep going? This one is from Philip Hartman, who's not here right now. He said, I am writing in reference to the zoning planning meeting being held to allow a variance for 108-110 Route 214. Please know my wife and I own house number 19 School Lane, which is in close proximity to the property in question on 214. We are against allowing the variances for a number of reasons. We feel the overall effect of a commercial establishment would have a negative effect on the locality in terms of I don't know what that says. Parking, noise. What does it say?
Overcrowding.
Overcrowding, parking, noise, transients, light pollution, and car traffic. The property is near a school, and many people, including my kids and grandkids, use 214 as a walkway to town. The property in question has advertised online, corporate events, weddings, concerts, etc. This sounds like a monstrosity is in the works. Lastly, it seems these folks have jumped the gun on this and not waited for the proper allowances to go ahead with this project. It calls in question their integrity. And the last one is from Mr. Calvin Smith, who's also not here. He lives at 90 Route 214. I am a concerned resident and neighbor in this residential area, and I'm opposed to having this variance for short-term rentals here. I object to the way these individuals took it upon themselves disregarding the zoning laws and opened without proper permits. They came to this residential area with the intent to open up a short-term business rental and have displaced 2 long-term rental units. With limited rental units in the Phoenicia area, this short-term rental in our residential community should not be allowed. We already have a legal motel next to this area, having many transients roaming around. The transients have limited respect for our area, walking over private property and doing whatever they feel like doing. To me, this is unacceptable in a residential area. Approving this variance is sending out the wrong message for the future that there are no laws west of the thruway. These individuals have shown no respect for our zoning laws in regards to this residential area nor the citizens living here. And he said, I was born and brought up here 89 years ago. After high school, service in World War II, and college, I was away for 50 years.